So this video is going to compare and contrast Salmon Chase, Salmon something Chase, Sam P. Chase versus Morrison Waite. Both of these guys were Supreme Court justices. And Morrison Waite, well, he's a piece of shit. And Salmon Chase, well, he's an absolute legend. Sam Chase is Sam Chase the Great. Salmon Chase, like the fish. Salmon P. Chase. Salmon P. What does P stand for? Portland. So Salmon Portland Chase is great. Morrison Waite is a grape. Salmon P. Chase is a god. And Morrison Waite is a devil. Just to tie it into history, Salmon P. Chase was the shining star of Reconstruction. He was the Chief Justice during a time of promise. Morrison Waite, however, he took Reconstruction to the Gilded Age. One of the biggest issues is Salmon P. Chase believed in the Bill of Rights. He believed that the Bill of Rights should be applied to the states. He believed in the incorporation process. Morrison Remick Waite, however, this fucking silly looking motherfucker, look at him, he looks like a goddamn baboon, don't he? Looks like a goddamn orangutan. Looks like an ape. Morrison Remick Waite was against the Bill of Rights. He was against the Bill of Rights. Let's just take two quick examples, and then I'm going to get into Salmon Chase's legacy, and then I'm going to point out all the bad decisions that the Waite Court had made. So, Morrison Waite, two big decisions. Minor v. Happersett. 1875, Minor v. Happersett, and 1883, Pace v. Alabama. So, Pace v. Alabama, 1883, the Waite Court is going to vouch and affirm the stupid Alabama law that forbade premarital fornication with black folks. He was against having sex with black women. If you had sex with a black woman in Alabama, the maximum sentence was 7 years. Hard time in the penitentiary. For Morrison Remick Waite, love is a crime scene. Let me quote something that the Waite Court had said about Pace v. Alabama. Or no, this is the law. This is the law that they upheld, Alabama law. 4189. If any white person and any Negro or the descendant of any Negro to the third generation inclusive, though one ancestor of each generation was a white person, intermarry or live in adultery or fornication with each other, that reminds me of the one drop rule. Each of them must, on conviction, be imprisoned in the penitentiary or sentenced to hard labor for the county for not less than 2 nor more than 7 years. Oh, that's it? Just 7 years? So Morrison Waite went ahead and upheld that. Pace v. Alabama. And so ultimately, what does that mean? Well, that means Tony Pace and Mary Jane Cox of Clark County had to go to prison for 2 years. You know, good job, you racist fucking piece of shit. Morrison Remick Waite. Minor v. Happersett, 1875. And Minor v. Happersett, he's going to say that women don't have the right to vote. He's going to gut the 14th Amendment. He's like, I know women were born in America, so therefore they should be citizens because of the birthright citizenship clause, and then their privileges and immunities should be upheld because of the 14th Amendment. But you know what? Nah, I'm not going to do that. Here's a quote from Minor v. Happersett. Bitches be crazy. Bitches be crazy and stupid were without any validity. Bitches be stupid and crazy whores. They don't have any validity unless a father or husband or son or brother can vouch for them. And since that damn bitch ain't got no sense, then them crazy bitches don't get a right to vote. That's consistent with Pearl. that YouTube star Pearl, she says that women don't deserve the right to vote as well. So Morrison Waite is against having sex with black women. He's against women in general. Half the damn country, half of the adults in the country being allowed to vote. And many more other terrible decisions. Now let's go to Salmon Portland Chase. Who is Salmon Portland Chase? Well, he was the Chief Justice. He was the Chief Justice, the 6th Chief Justice from 1864 to 1873. He was the founding father of the Republican Party. He was born in New Hampshire in 1803. He's an Episcopal Christian. He held positions in all 3 branches of government. He was a senator, U.S. Treasury Secretary, and Chief Justice. He was also the governor of Ohio. This is the founder of the Republican Party. Chase Bank is named in Salmon P. Chase's honor. He wanted to nationalize the Bill of Rights. He was in favor of the incorporation doctrine. Salmon Portland Chase was the leader of the Free Soil Party. Before it became the Republican Party, it was the Free Soil Party. He was actually a contender against Lincoln. Now let's talk about some of the decisions that Salmon Portland Chase had made. Texas v. Waite, 1869, he says that the United States are perpetual and indestructible. The 50 states in the Union are perpetual and indestructible. You can't destroy any of the states or the Union. I don't know if there was 50 states back then, but all the states at the time. He said secession is unconstitutional. Secession is unconstitutional if you don't have a revolution, number 1, or number 2, you don't get consent of the Union. Either you get consent of the Congress or you declare a revolution. Those are the only 2 ways you could get out of this union of states. Some people say that states are the imaginary state, but it's actually perpetual, indissoluble, indestructible. They're immortal. The American government is immortal, and the 50 republics are immortal as well, according to Texas v. Waite. Vinzi Bank v. Vinzi Bank v. Finno, 1869. He upheld 10% federal tax on state-issued banknotes because Congress gets to regulate banking and money. Hepburn v. Griswold, 1870. He said that paper money is not legal tender prior to 1862 because of contracts. He upholds the contract clause. Hepburn v. Griswold, Vinzi Bank, Texas v. Waite. He dissented in the slaughterhouse cases, 1873. The slaughterhouse cases are going to gut the 14th Amendment. But he says that the Bill of Rights matter and the 14th Amendment is important. Of course we have freedoms. If you're an American, you have the freedoms of the Bill of Rights. He also upheld habeas corpus, even during wartime with Ex parte Milligan, 1866. He also ruled on Ex parte Ends, 1866, and Georgia v. Stanton, 1868. A quote from Texas v. Waite is, "The Constitution is of an indestructible union composed of indestructible states." Salmon P. Chase also presided over Andrew Johnson's impeachment trial in the Senate. He also one time defended a fugitive slave named Matilda. So 1864 to 1873, Salmon P. Chase is the Chief Justice of the United States of America. But then he's going to die or retire. I forget which one. But he's not going to be the Chief Justice after 1873 because you're going to have Morrison Waite. Morrison Waite is going to get in there by the skin of his chinny chin chin. How did Morrison Waite get into office? Well, he was U.S. Grant had picked him. So, not the Lincoln shadow, but not Lincoln. Lincoln had appointed Salmon Chase. U.S. Grant had appointed Morrison Waite, but it was U.S. Grant's third choice. So he was a compromise candidate. At first, U.S. Grant had asked a couple people, Conklin, Howe, Morton, and Fish, if they want to be the Supreme Court Chief Justice, and they all told him no. And then he went ahead and nominated George Henry Williams, but it came out that George Henry Williams had used public funds for a fancy carriage. So then his nomination was pulled, and then Caleb Cushing was nominated for 5 days only because old letters were dug up that tied him to Jefferson Davis at the beginning of the Civil War. Whoops. Whoopsie daisy. We don't want a goddamn Confederate to be the Chief Justice. Come on, U.S. Grant. So the third choice that U.S. Grant was going to pick is this Waite. And who is this Waite? Well, he had no controversies. He came out of Ohio, and I think he came out of Ohio. But he was obscure, second-rate, low energy. He was a lawyer who won $16 million in reparations from Britain for supporting the Confederate. And he was unanimously confirmed 63-0. So Mr. Boring, Mr. Obscure, Mr. Second Rate. There's a quote that says, "You can't make a silk purse out of a cow's ear." That's what Justice Miller said of Morrison Waite. So he's the cow's ear. And with the cow's ear, you can't make a silk purse out of a cow's ear. Fucking Morrison Waite. Jesus Christ, let's look at some of these pictures of this guy. Oh, hi, I'm Morrison Waite. I got this big old prominent beard. I'm 500,000 pounds, and here I am with a ginormous head. Ginormous head for a ginormous body. Fucking disgusting, fat, overweight, anti-freedom, anti-Bill of Rights, piece of shit. Jesus fucking Christ. Alright, let's get to what Morrison Waite. What did Morrison Waite? What all did he rule on? What did the Waite Court? They were in power from 1973 to when? 1973 to, I don't know, 1880 something. No, not 1918. Excuse me, let me go back for a second. He's going to be the Chief Justice from 1873 until 1888. 1873, halfway through it, to 1888. So whereas Salmon Chase was only Chief Justice for 9 years, this fucking prick is going to be Chief Justice for 14 and a half years. So he got to be Chief Justice for 4.5 more years, 5.5 more years than Salmon Chase. The ultimate judge of how good a Supreme Court justice is are their opinions. These are their opinions. They issued them publicly. They didn't feel bad about them. They put them out there. They're the ones that are in charge. So we already know Morrison Waite don't think women have a right to vote. And here's an actual quote from that decision. The argument is that as a woman born or naturalized in the United States and subject to the jurisdiction thereof, this is Happersett, is a citizen of the United States and of the state in which she resides, she has the right of suffrage as one of the privileges and immunities of her citizenship, which the state cannot by its laws or constitution abridge. There is no doubt that women may be citizens. Maybe. There's no doubt that they may be citizens. Why would you say no doubt and then maybe right after no doubt? Being unanimously of the opinion that the Constitution of the United States does not confer the right of suffrage upon anyone, that the constitutions and laws of the several states which commit that important trust of men alone are not necessarily void, we affirm the judgment. So the American government can't say that women have a right to vote because that power belongs to the states. And as long as the states are saying that bitches be crazy, well, he's going to uphold bitches be crazy. That's Minor v. Happersett. And Minor is Virginia Minor. And that was a unanimous decision. So he was able to get the entire court on his side. Half of the damn country, half of the citizenry were so far inferior to men that they didn't even deserve the most rudimentary of rights in Missouri. Carrying on, what other stupid-ass decisions? He's going to be the one that's behind U.S. v. Crookshank, 1875, U.S. v. Reese, 1875, Loan Association versus Topeka, 1875, Elk v. Wilkins, 1884, the civil rights cases of 1883. Santa Clara versus Southern Pacific, 1886. Reynolds v. U.S., 1879. Presser v. Illinois, 1886. Powell v. Pennsylvania, 1888. Civil rights cases, 1883. Hurtado v. California, what was that, 1873, 83, something? The Hurtado v. California decision. Now let's go with Crookshank. Okay, so he's going to gut the 14th Amendment. He's going to say the Bill of Rights doesn't apply to the states. It's just more of a symbolic thing. It's more of a suggestion box. If the states want to uphold the Bill of Rights of the U.S. Constitution, that's their prerogative. It's up to the states. The 14th Amendment doesn't mean what it says, and it doesn't say what it means. U.S. v. Reese, 1875. U.S. v. Crookshank, 1875. And the civil rights cases, 1883, is going to gut civil rights in America. The Bill of Rights don't mean shit, just a suggestion. It's just a symbolic suggestion for the states to uphold if they wish, if they please. Ironically, state constitutions also say that they're going to uphold freedoms, but hell, if the Chief Justice doesn't want to uphold the freedoms, then why should the states uphold the freedoms? Talk about an area which these courts are supposed to be jealously protecting their powers. What a great area to fill the void of law into, upholding our constitutional rights. Santa Clara v. Southern Pacific, 1886. Morrison. Waite Court is going to say that corporations are people. Corporations are not a piece of paper in a filing cabinet, but they are actual American citizens who get Bill of Rights protections. So women don't get Bill of Rights protections. Black people don't get Bill of Rights protections. But corporations, Santa Clara v. Southern Pacific, 1886 says yes. Reynolds v. U.S. This has to do with Mormon polygamy, 1879. They're all consenting adults. Presser v. Illinois, 1886. He says no to the Second Amendment. He's going to say no to the Fifth Amendment in Hurtado v. California. No to the Fifth Amendment, no to the Second Amendment. Does he believe in any of the amendments? McDonald decision 2010 overturns Presser v. Illinois, 1886. This had to do with Herman Presser, who marched on the streets with some guns, like a well-regulated militia. He got fined $50 for doing it. So, of course, according to Morrison, Waite, he doesn't believe that there should be a national floor to the nation's liberties. There shouldn't be a national floor. The 10 Bill of Rights, we can't at least make the 10 Bill of Rights the law of the land. When it comes to the Fifth Amendment, the grand jury, that goes all the way back to before the Magna Carta, to the Assize of Clarendon of 1166. So that means for nearly 1,000 years, 800, 900 years ago, we've had the grand jury, but that ancient immunity, which was upheld by Coke and Bracton and Blackstone and all the common law authorities, before America, during America, after America, even Nixon, Clinton, Trump, they've all had to face grand juries as well. In the federal courts, you can't get a felony charge to go forward unless you get an indictment first. But we're only going to do that for the federal courts. We're going to restrain the federal courts, but we're not going to apply the Fifth Amendment or the Second Amendment to the states. No incorporation. Hurtado v. California, Presser v. Illinois. The civil rights cases are going to do the same thing. The civil rights cases, 1883, says that it only applies to the states. The 14th Amendment does. Or the Bill of Rights. The Bill of Rights do not apply to the states. So the 14th Amendment only restrains the federal government. The states can destroy whatever goddamn freedoms you have. But here's the thing about being an American. You got to live in a state. Which jurisdictions in America is not a state? The only way you could say that you're an American, just pure, through and through, you're an American, but you're not, Floridian or Montanan or Californian, is what, D.C.? Only in D.C. are you strictly an American and you're not a creature of a state government? That had to do with private discrimination. So he says it's all right to have private discrimination for private companies, private corporations. Federal government's restrained. The state governments are not restrained. This is going to kill Reconstruction. This is going to get us into the Gilded Age. This is going to allow violence and terrorism It's going to go ahead and green light violence and terrorism. The Loan Association versus Topeka, 1875, is government can't lend to private parties. U.S. v. Reese, 1875, says that, again, the 14th Amendment only applies to the federal government, not the states. It's narrow interpretation of the 15th Amendment. Do black men have a right to vote? Well, sometimes they do and sometimes they don't. U.S. v. Reese is going to struck key provisions of the Enforcement Act down. What had happened in Louisville, Kentucky, they were stopping black men from voting. The black men who went to Louisville, Kentucky to go vote, they were escorted away by the police. So we're going to say the 15th Amendment, which is a pretty weak amendment, just saying that if you're a black man, you have a right to vote. And then a feminist critique of the 15th Amendment was, you're going to give black men the right to vote before you give women the right to vote? But apparently not. Not even black men got the right to vote. Elk v. Wilkins, 1884. Apparently for Morrison Waite, not only does he not care if black men vote, not only does he not care if black women have any rights, or he's going to say love is a crime scene. He's going to say women don't get a right to vote. They're not citizens as well. In Elk v. Wilkins, he's going to say that Native Americans are not citizens. Well, he just keeps on kicking people out of this American citizenship club left and right. He's going to deny a Native American voting rights. Because if you're born in a reservation, the guy was born on the reservation in Elk v. Wilkins, 1884. But he lived in Omaha, Nebraska, lived there his whole life, had a business and a home. Essentially he renounced his, tribal allegiance. But he's not an American. He was born on this soil, but he's not an American. There was two dissents with Elk v. Wilkins. Let's talk about U.S. v. Cruikshank. U.S. v. Cruikshank is one of his most worst decisions ever. So you had the Colfax Massacre. And what happened with the Colfax Massacre, this had to do with the 1872 election of the Louisiana governor and local elections. So this is going to be in Colfax, Louisiana. So the Republicans said that they won the election. The Democrats said that they won an election. And the sheriff of Grant Parish and the judge of Grant Parish and some militiamen took the courthouse over because they said they won the election. So they were armed, but there's no violence. They were occupying the place. You're allowed to peacefully assemble. You're allowed to peacefully assemble, redress your government for redress of grievances. Well, Cruikshank isn't going to like that. And so Cruikshank, this is an actual guy, William J. Cruikshank, he led a group of armed men. They took 50 black prisoners, and they took them into the middle of the street or into the woods or something and fucking killed them. Levi Nelson is going to live, and he's going to testify against Cruikshank. But Cruikshank was a part of straight up murdering either 62 to 153 black men and 3 white men with the Colfax Massacre, which is what happened with that disputed 1872 election of the Louisiana governor and the local elections. That was a 9-0 unanimous court. So what happened to those murdering sons of bitches, those terrorist pieces of shit? Cruikshank is going to summarily execute the surrendered and unarmed Americans. But apparently murder didn't break the Section 6 of the 1870 Enforcement Act to injure, oppress, threaten, or intimidate Americans from exercising their rights, which is codified 42 U.S. 1985, Section 3 today. So the killers got away with their perfect crime. There was only 3 fucking guys that had an indictment, federal charges against him. Morrison Waite, you couldn't press goddamn charges for fucking murder? We don't know if murder is illegal in America. We don't know. That's not really a crime. Really? Murder is not a crime in America. And then, so they try to do it through the Enforcement Act. I don't know. When you murder somebody, you pretty much injure, oppress, threaten, and intimidate their freedoms, right? You take their life. You take away their freedom too. And if they're dead, they can't exercise any of their freedoms after they're dead. Justice Bradley had opined that it can never be endured that the white shall be compelled to lodge and eat and sit with the Negro. That was the civil rights cases, 1883, that had to do with the Civil Rights Act of 1875. Malcolm X had pointed out that the Civil Rights Act has been passed 4 or 5 times before 1964. And even though the Civil Rights Act has been passed 3 or 4 times before 1964, that still didn't uphold integration. That still didn't uphold the rights of black men and women and children and elderly. And so, Elk v. Wilkins, Native Americans are not citizens. Minor v. Happersett, women are not Americans. Pace v. Alabama, if Alabama wants to maintain a marriage ban and a sex ban, and you can't have interracial sex with the threat of 7 years, a hard time in the penitentiary, that's their right. Government can't lend to private parties. They can't help a private company build their business up. U.S. v. Reese said it was okay for Louisville, Kentucky to stop black men from voting. He's going to gut out the Enforcement Act. He's going to gut the 13th, 14th, and 15th Amendments. And that's going to gut the entire Bill of Rights. U.S. v. Cruikshank had ended Reconstruction. 153 black men were killed and 3 whites. This invited violence, lawlessness, terrorism. Here's some of the names of the people that had died in the Colfax Massacre. Here are some of the names of the ones that lived. William Ward was the leader. William Ward was the leader, and William Ward had lived and testified. Dan Shaw was the sheriff. Robert Register was the judge. You also had Louis Melands. And a guy named Flowers, or somebody named Flowers. Some of the dead that were killed in the Colfax Massacre: Jesse McKinney, William C. Brown, Calvin Edwards, James Jackson, Henry Fleming, Henderson Dean, William Smith, Henry Weathersby, John Williams, John Young, William H. Calhoun, Ned Green, Henry Clay. A guy named Henry Clay was killed. And the 3 Caucasians: James W. Hadnot, Sidney Harris, and Stephen Decatur Parrish. Sidney Harris, Steve Parrish, and James W. Is that Hadnot or Hodnot? But William C. Brown's not going to get any justice. John Williams isn't going to get any justice. John Young, Ned Green, Henry Clay, they're not going to get any justice. Why? Because of some stupid bullshit loophole that Morrison Waite had saw through. He thinks corporations are people and they deserve the Bill of Rights. So corporations deserve rights, whereas women, Native Americans, black people don't deserve rights. And actually, don't all Americans deserve the Bill of Rights? If you're born in this country, you get the Bill of Rights. And I thought that was a thing. Powell v. Pennsylvania, 1888. Morrison Waite also had a problem with margarine. There was a law that prohibited the sale of margarine. It had to be made of milk or cream. Butter did. He upheld that law. That was real important, to prohibit the sale of margarine. So this guy sucks. This guy sucks. Morrison. Goddamn Remick. That's his fucking middle name, Remick. Just judged by Portland versus Remick. Who could trust a Remick? Hey, what's your name? Remick? Like you Mick again? What? Well, Remick, like repeat, you do the thing over, retie, rerun, Remick. So Morrison, Remick Waite, total degenerate, low-life, disgusting piece of shit. Salmon Chase. Let's look at some pictures of good old Salmon Chase. Kind of an old, bald white guy. Not too, he's more charismatic. He was more charismatic than Morrison. And he carried the promise of the Civil War and Reconstruction. He's got some flaws himself. He ain't perfect. But just to compare him with somebody in his own era, the previous Chief Justice, John Roberts, will be compared to William Rehnquist. And let's see here. Let's go over this just to make sure I haven't skipped over any of these cases. Salmon Chase was Texas v. White, Vinzi Bank v. Finno, Hepburn v. Griswold. He dissented in the Slaughterhouse cases, 1873. Slaughterhouse cases was ridiculous. A monopoly. They were going to let the slaughterhouse monopoly kick all the butchers out. I want to say this is in Louisiana as well. What the fuck is going on with Louisiana? Ex parte Milligan, ex parte Inns, Georgia v. Stanton. So those are the decisions I reviewed for Salmon Chase, Morrison, Waite, Crookshank, Powell v. Pennsylvania, Santa Clara v. Southern Pacific civil rights cases, Reynolds v. U.S., Presser v. Illinois, Hurtado v. California, U.S. v. Crookshank, 1875, U.S. v. Reese, 1875, 1883, Pace v. Alabama, 1875, Minor v. Happersett, Elk v. Wilkins, 1884, Loan Association v. Topeka, 1875, Reynolds v. U.S., Presser v. Illinois. I think I got them all. The legal tender cases, he was actually important when it came to the greenbacks. He was actually a staunch hard currency guy, so he believed that the gold and silver clause was supposed to be taken literally, but during the war, they started issuing greenbacks, and then when he became Chief Justice, then he says, okay, I'll accept paper money after the legal tender cases of 1862 were upheld. So he kind of evolved with the times. His dissent in slaughterhouse cases, no, you should, the 13th Amendment, the 14th, and the 15th Amendment matter. And they apply the Bill of Rights. They apply the Bill of Rights to the states. He believed in full incorporation. So he believed, the founder of the Republican Party believed that the Bill of Rights were freedoms that all Americans who were born in this country and therefore are entitled to citizenship, that we get those rights. I got Ex parte Virginia, 1879 here off to the side, and there's also Bradwell v. Illinois, 1873. That was a controversial decision. I'm not too happy about Bradwell v. Illinois. But yeah. So long live Salmon Chase, and rest in piss, Morrison Waite. Rest in piss.